All right. So this is, again, ERD case number 2020-00-263. The complainant again is Gregory Mitchell, and the respondent is Balaji Transportation. And on behalf of Balaji Transportation, we have the respondent's attorney, who is Maxwell C. Livingston, and we have the respondent's principal person representative for the respondent, which is, I can't say your first name. Can you say it, please?
Sukhpal Singh Kelly.
Okay, Sukhpal Singh,
Kelly.
and Kaylee. So Kaylee, and could you spell that for the record so we have it, please?
First name is S as in Sam, U, K, H, P as in Paul, A as in Apple, L as in Larry. Sukhpal.
And the last name spell, please.
Kelly, K as in kite, A, I, L, E, Y.
Okay, I was missing an E. All right, good. All right, thank you very much, Mr. Cayley.
You're welcome.
So, appreciate it. So
you.
we went off the record because the parties want to talk settlement. It's now 11:38, so we've expended quite a bit of time on discussing settlement, and we have reached a settlement, or the parties have reached a settlement. The terms of the settlement are confidential, so we will not be discussing them on the record, but we have gone over those terms prior when we were off the record, and it's my understanding that everybody agrees to those terms. So I want to make sure that that's the position we're in before we take this matter off the calendar today. I do want to be very clear, as I was clear when we were off the record, that if for some reason either party decides that they don't want to proceed with the settlement, that we will come back to this matter and do the hearing in front of me, again, at a different time, in the same status posture that we are in now. That means Mr. Mitchell has no witnesses. Mr. Mitchell has no exhibits. He will not be able to supplement the record for that next hearing. I don't allow parties to agree to settlements for the purpose of then trying to get a better position for the hearing when they're not ready for the hearing. So it's up to the parties to be ready for the hearing. This matter has been scheduled for several months. We even got an additional month's time to be prepared. And so I'm not going to allow any further supplementation of the record. I don't think that's going to be an issue because I think the parties are going to go forward with their settlement, but I just want to be clear about that. So Mr. Mitchell, you understand that?
Yes, I do.
Okay, and so I don't want you to talk about the terms, but I want to be clear that we have discussed the terms of the settlement while we were off the record. Is that correct?
Yes.
And you understood those terms?
Yes.
And you are planning to, at this point, you have every intention of going through with the settlement, correct?
Correct.
And you understand it is your obligation to either represent yourself or to hire an attorney to review that document, that settlement document, before you sign it and date it, because it is your responsibility to decide that. I'm not your attorney. Mr. Livingston's not your attorney. You are responsible for doing this. So you need to be sure that this is an agreement that you can live with and that you are actually agreeing to abide by. Do you understand that?
Yes, I do.
Okay, so although I expect that you will be signing it, if you decide that you don't, that is up to you, correct?
Correct.
And if you do sign it, you will agree to be bound by those terms, correct?
Correct.
Okay, and that's a voluntary decision on your part. It's not something we coerced you into doing.
Yes, it is.
It's voluntary.
Voluntary.
Okay. All right, Mr. Livingston, let's talk to Mr. Cayley. Mr. Cayley, have you had a full and fair opportunity to consider the terms of the settlement as we've discussed them here today off the record?
Yes, Your Honor.
And have you had a full and fair opportunity to discuss those terms with your attorney?
Yes.
Okay. And to the extent that I know there's some issues that you want to discuss with him yet, but generally you're agreeing to be bound by the settlement as we've discussed it here today?
Yes.
Okay, so I will understand that to be also a voluntary decision on your part?
Yes.
Okay, so you are responsible for your ultimate decision, although Mr. Livingston is your attorney and will be providing you with legal advice. You are still ultimately responsible for making the decision as to whether or not you settle or don't settle, correct?
Correct.
And then you understand that if you decide you don't want to settle, you can make that decision, correct?
Correct.
But if you don't go through the settlement, we will come back to hearing in the same way that we are now. You understand that?
Yes. From other side is final.
Okay, good. All right. So, Mr. Livingston, is there anything or issues that we need to handle from your end as the response attorney?
No, Your Honor.
Okay. All right. Then I am anticipating getting a withdrawal document. I'm hoping, based on what we've discussed, that maybe by Christmas I would get that withdrawal document. Do you think, Mr. Livingston?
Yes, assuming that it meets with form and is executed within a fairly consistent with customary business practice, then that would be my understanding. But obviously, it requires things that are outside my control of both of the parties. But yes, that's my belief.
Okay, so you should understand, I will not dismiss this until I know that everything's been completed. I will once I get the withdrawal document that's signed and dated, I will contact Mr. Mitchell and say everything is done correct. And as long as he tells me that it is correct, then I will move to dismiss the case. You understand that, Mr. Mitchell?
Yes, I
So
do.
expect a call from me, and then please answer and let me know that it's okay. Okay?
Will do.
All right. And then I should let you know too that I am going to be gone on vacation after the 17th of December. So if you send me anything after the 17th of December, I will not be able to handle it because I will be on vacation until January, till after the holiday, till after New Year's. So if you want this dismissed before Christmas, you need to get it to me before the 17th of December because I actually have a hearing the day of December 17th, and I may not be able to get to a dismissal on that day. So just plan your calendars accordingly if that's something you want. I'm certainly willing to wait till January. If you can't get it done with the holidays, it's often very difficult to get things done quickly. But if you are looking for that to be done early, then you should do that before the 17th of December. So any questions or concerns about that, Mr. Mitchell
No, it's not.
and Mr. Livingston?
Only that I hope you enjoy your holiday.
Oh, thank you. I hope everybody does. But you should know, I believe because we've been emailing the witness list and copies of exhibits, you have Mr. Mitchell's email address, correct?
I believe so. Can you just confirm the email address, Mr. Mitchell, just to make sure there's been no change and that I get it to the right place?
It's G414-252-3517
Okay, I believe that's the same as the one I have, but just in case, thank you.
Okay, and then you've gotten documents with Mr. Livingston's email address on it as well, Mr. Mitchell. So if you need
Yes,
to
I do.
contact him by email, you will have the ability to do so, correct?
Correct.
Okay. The important part here is communication. Please make sure you are talking to each other and communicating so that things can get done. When you don't communicate, things go wrong. So please make sure we are talking in a civil tone to each other and find a way to move forward to get this done. And again, let me know if there's a problem and maybe I can discuss it with you if I have an opportunity that works out with everybody's calendar. All right?
Okay.
Thank you, Judge.
Okay, thank you, and
Thank
have a
you.
good Thanksgiving and Christmas holiday and New Year's. Everybody enjoy
Thank
your
you. You
time.
too.
You too.
Take care.
You
Okay,
Have
too,
a good
Judge.
day.
Thank you, everyone.
Thank you.
Thank you.
Hearing's adjourned.